So don't tell me I question your ethic. You're going to be found in contempt. I'm done, Ms. Toe. You took funds that would have been client funds and somehow took them into your possession to redistribute.
Their actions appear intended to harm my family financially.
Housing 401k plan versus Erica Ward.
Good afternoon, Your Honor. Steve Otherly on behalf of Plaintiff Fixing Housing, 401k plan.
Good afternoon, Donna Tope on behalf of Erica and Aaron Ward. They are the tenants in this lease.
All right. Where are we now, folks?
So my understanding is after the long conversation that we had last Monday, that this hearing was held in anticipation of my action or interaction. And I would, if I filed a withdrawal, then the hearing wouldn't be held. And
If you filed it I don't think I said that.
well, you didn't say it, no. But you said that if circumstances worked out the way you were suggesting, there were two choices, and that's why this hearing was being held. Do I not have it correct?
I don't know what you have. Keep going.
Okay. So I'm here because I would like to
Before we dive in, just a quick note. This commentary is created for educational purposes, designed to help those who may be confused or curious about courtroom processes. If you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned. It's about to get intense.
Specifically states the lease is for their use as an animal farm. The property is zoned agricultural and has been used lawfully for over 25 years as an equestrian center with several major outbuildings and one residential unit. This lease began in 2021, just 3.5 years ago. The lease terminates in 3.5 years from now. None of the land is zoned commercial. None of the property is used commercially.
Why are you telling me this now?
And the lease is not a commercial lease because several times plaintiff has referred to this as a commercial lease. And I heard this court repeat that this is a commercial lease. There are different standards applied to commercial property and commercial property that is leased.
All right, then all you have to do is say, without this long rendition, that you don't believe it to be a commercial lease.
Okay. Well, I felt I need to just restate what I had said in my answer. It didn't seem to have been heard. I have been associated with Erica Ward.
I hear everything. So whether I react to it becomes a whole different thing, but I hear everything. Go ahead.
Well, I have been associated with Erica Ward for over 3 years in consultation with me as a property manager through my solo-owned property management company. She consulted with me over these past couple of years over many serious, dangerous conditions the landlord had refused to repair. I gave her the City of Ann Arbor information required to be provided to tenants by landlords and the Michigan State University Law Center's information for tenants and landlords, both of which describe the right of the tenant to withhold rent and pay for necessary repairs for the health and safety and habitability of the rented property when the landlord has refused to make the necessary repairs. Our answer filed with this court had the circuit court case attached, which was filed in July 9th of 2025. The jurisdiction for our breach of lease case was with the circuit court. And our answer describes the necessary repairs the landlord refused to make since 2023 which is his duty under the terms of this lease for agriculturally zoned property.
You
Erica
can't
Ward.
have it both ways.
Hmm?
You can't have it both ways. If you're going to claim, so, and counsel, before you go on, I think you need to do your legal research. If you're going to claim that this is not a commercial lease,
Yes,
and it's a 7-year lease,
yes.
then the obligations regarding repair change.
That, I think that would be something to bring up by the plaintiffs, in, to rebut what I'm
No.
saying. Erica Ward asked me to be her attorney in the middle of July to file a complaint with the court over the landlord's waste and interference with her use of the property, which had caused her damages. This complaint was filed
I don't know why I need to know all of this.
because, Your Honor, you have questioned my ethical ability
I
to
have not
represent.
requested, I have not. What I have said is that if indeed you took funds that were the landlord's funds, the capacity that you're operating in is going to be a problem, counsel. That is what I indicated. If you don't see it as a problem, then so be it. But I think on its face, it's a problem. Any question regarding your ethics is your own. Because I'll tell you right now, if an attorney comes before me and I think that they have done something that I can show that they have done unethical, you will be reported to the Attorney Grievance Commission in a minute. So I did not do that.
No,
So
you-
don't tell me I question your ethics. I question the question. You know what? I don't need the dramatics. Any more dramatics, you're going to be found in contempt. I'm done, Ms. Tope.
Yes. Yes.
What I said to you and what I was indicating is that you took, as you stand before me, the wards are your clients. What I am then told is that you took funds that would have been client funds and somehow took them into your possession to redistribute. Your argument may be that you did it for other reasons.
I would like to state the facts behind the assumptions that I took client funds. I did not. Erica told me that she wanted to, I was consulting with her as a property manager. I was not her attorney.
And if that's your position, that's your position. From the court's perspective, it looks different, which is what I was pointing out.
Yes, and you clear, and
And if I want to make an accusation, Ms. Tope, I am not shy. I will clearly make that accusation, and I have not.
you were very clear that it was not an order, it wasn't an opinion, it was words. But I tell you that words have consequences because we are on YouTube.
So does one's actions. Ms. Tope.
Yes, yes,
Whether YouTube or not, it doesn't matter. This is a public record.
yes.
And all I am telling you is that the court saw concerns.
Yes, and I am here to address the concern so that it's on the record as well, so that,
Ms. Tope, no. I have given my admonition at the last hearing. The wards may proceed in whatever fashion they wish, given You may proceed in whatever fashion you wish. If I thought you were doing something unethical, I would myself remove you from the case. I have not done that.
No.
So I'm done with this issue.
Today. You are done with me today, or?
I am done with that issue.
Okay. Thank you.
Your Honor, this is the first I'm hearing about a property management company that's holding rent payments. I don't know who the property management company is. I don't know what the bank account is. You ordered tenants to produce an accounting. They did that. It's a mess. And my client is the one who's being prejudiced by that. Actions do have consequences, and the consequences of their agent, or the actions by tenant's agent, have consequences. And they didn't have the right to withhold rent payments. That's what they did. These are grounds for default under the lease. The lease should be terminated, and they have to deal with the consequences. Now, if tenants, they may have their own recourse separate from this action. That's their decision. That should not be with my client, and my client shouldn't have to keep fighting over alleged ethical violations.
They did not have the management agent. She consulted with me about my opinion for over 3 years. I had no jurisdiction over the property. It was completely Erica and Aaron's tenancy, and I was not their attorney. Was I their property manager?
It's true.
Yes.
It's those statements which give the court pause. When you're saying that they consulted with you regarding the property, and
Not in my capacity. I was taking writing lessons, and she was telling me what was going on, and I gave her some of my advice, but not in a professional or proprietary or contractual
that way. Okay.
as a friend.
Okay.
I think Ms. Hope's property company should be a party. She has inserted herself into this litigation, and this went from a simple non-payment of rent and has ballooned because of tenants through their counsel's actions, and it has become a mess.
We filed a circuit court case was filed July 9th, long before this court had jurisdiction. In my first response as their attorney for this court, I asked for an escrow fund to be set up, a trust fund to be set up by the court, and you did that. Anything done before that was not in, there was no money put in any trust fund.
Can I just say, so this, let me just ask this. Counsel, are you,
I need to step closer to here.
are you going, we can get the equipment for Counsel, are you going to file a motion to add Ms. Tope and this as a party to this action? I realize I'm asking you on the spot because you're first hearing about it, and I know that there would be things to be taken into consideration in doing that.
Obviously, I'd have to discuss with my client. It's something that I would like to avoid. I think the language of the contract is clear that they didn't have the right to withhold payments, and that these are grounds for defaults, and that the lease should be terminated and there should be an eviction order. But But if we have to keep going this back and forth way, we may have to. Especially if it's a third party that's handling funds, handling the rent funds, then we would have to.
No,
Were you the property manager for them?
no,
Were you involved in the payment of funds to contractors?
only in the account that Erica used to withhold her funds. And
What do you mean by that? Who were signatories to that account?
Erica approved all of,
Who were signatories to that account?
I was,
There's our problem.
but not my
Okay,
attorney.
so, no. That's our problem. So, who else was a signatory to that account?
No one else. Me and me alone. And
Okay, Miss,
the money was filed after we filed the circuit court case.
no, it doesn't matter.
And this court.
Doesn't matter. It doesn't matter. It doesn't matter. Do you not see a potential problem with that, Ms. Tarver? That's a yes or no. If you don't, I don't know what to say.
I see that someone could make an issue out of it. But I don't see a legal problem. So when you say a problem,
Let me ask this,
yes.
since you're given that information. And just think about this for a moment.
Okay.
Whether you believe it to be true or not.
Okay.
Plaintiff claims that the tenants cannot withhold rent in this fashion or make repairs and take that off of the rent. Okay? Tenants do that.
Tenants had done that before they claimed that.
Whoa. Tenants do that. Tenants acknowledge they've done that. And that you are the one that did that on their behalf. Why? What happens given that factual scenario, which I don't think is far from the truth based on what I know, if they file a claim not only against the wards but also as to you?
I'd have to show why it's not appropriate. Mostly because they were notified that rent would be withheld before it was withheld, and they were notified the bank account that,
So if their claim is you can't do it,
well, I
if
guess,
their claim is you can't do it,
yes,
and that the wards could not do it, but then you were the one that did it on their behalf. Good, bad, or indifferent. You're the one that did it. Don't you really yourself become a necessary party to this action? And that's what I'm saying. If you're a necessary party, Ms. Tope, you can't be the attorney.
Okay. Okay. I hear what you're saying.
Mr. and Mrs. Ward, do you understand what the court is indicating? I mean, whether you agree with it or not, it's not my issue. You understand what I'm getting at?
Yes.
And so that I'm clear, and what I was trying to be clear at the last hearing, was I did not want a circumstance where Ms. Tope, you're brought in as a party, and then your clients are left without representation. It's just an issue of the fairness of all proceedings. It doesn't have to do with whether I like somebody or not, or what position I'm taking. So, Ms. Tope, with that understanding, what are we going to do? I don't want to get so far down the line.
We're off track for sure.
That what?
We are on this case. We are off track. Get it back centered. I would do whatever's required to be able to deal with the issues at hand and not clog up these proceedings any further.
I don't know what that means.
Well, I'm sorry, that's the only way I can say it.
Your Honor, we're off track due to tenants' agents' conduct. By taking actions that were not allowed under the lease in the first place. And this is our third hearing in 3 weeks. And my client is going without any rent payments. He got a partial payment, but he is the one who's being prejudiced by us having to keep coming to court when tenants didn't have a right to do this in the first place. And they have to accept the consequences for their agent's actions.
I was not their agent.
Okay. Then what were you?
I was their friend, and beginning July 9th, I was their attorney in a circuit court case. And they didn't file.
I'm not going to go through what you want, what name you want to place on it. Counsel, you know how the terms agent are defined under Michigan law. So the fact that you are somebody's friend does not mean, for the purposes of agency law, that you may not be acting as their agent.
Well, that one would have to prove I was acting as an agent rather than a friend in order to put the official together as an agent.
Ms. Tope, I don't even know how that comes out of your mouth. If you're saying that they had money and repairs that needed to be done on property that they lease, they own the property that they're leasing, and that you, whatever name you want to place on it, take funds as the only signatory to an account of theirs and do things with it, reference the property, pretty much acting as their agent.
I will prepare withdrawal papers and have them sign it. We've talked about this. They're in agreement after this.
Then what? Why don't we start there? Nothing. All right. So you're going to withdraw as counsel?
Yes.
All right. And then, folks, are you in the position right now that you have counsel, or how? No. How much time would it take you folks to get an attorney? You think?
Wouldn't know where to start, so I have to look into that.
We typically offer.
Pardon?
We typically suggest.
Well, I don't know. I don't want to bring you back for a hearing and you don't have someone to represent you, but I about to go into December. December, the escrow is going to have to be paid. So while plaintiff's not getting it, it's going to have to be paid to the court. And escrow was deposited with the court. If you don't know that, it did get deposited.
Your Honor, I received a handwritten note. I couldn't read it, but that's good to hear that they did follow.
A handwritten.
I received a handwritten note that I don't know what.
Oh, that was my written request because the court was not available Friday after our hearing. That we went to the clerk to pay the escrow, and we were told that we had to get permission from the court.
To pay it at certified funds as opposed to cash. Yes.
They paid it. Okay.
And I filed that with the court, and I gave you a copy so that you knew what I had done in order to try to get the amount paid. And they also advised me that since this case is really in 14A4, but they can't take funds here at 14A1.
Yes, they can.
Well, they say that it's put into a bond and it's very complicated and,
I don't care how complicated it is. They can take the monies here.
well, okay,
They don't have to drive up.
I deposited it.
It doesn't matter.
I like
Whatever.
the drive. It was a nice drive.
Okay. So the 4125 is, my point is that is in escrow.
It has been paid.
And that I have the expectation that the 5,500 will be paid within days of December 1st. All right. So I'm going to give the wards time to find counsel. So I'm going to adjourn this to December 19th. Allow them to get counsel and allow counsel to, once obtained, to get up to speed on everything that has transpired. Pardon? All right. So I'll adjourn this matter to December 19th, 2025 at 1 p.m. you said?
Yes.
1 p.m.
Your Honor, my client would like to say a few words.
That's fine. Yes, go ahead.
Thank you. Thank you.
I don't really want much in regard to the substance of the case, but go ahead, sir.
Thank you. Your Honor, so my background is I'm a family man with 6 children. This property is our family's entire retirement. I was adopted, worked my way through school, started a mortgage company in 2003 that's operated for 22 years without a single bad review. I've served on the board of the directors for the Arthritis Foundation and Entrepreneurs Organization. I work with the Congressional Medal of Honor Society. I spent over 10 years coaching and sponsoring at-risk youth for football and baseball, including future Maryland running back Nolan Ray. We have saved our entire life to be able to purchase this property. The tenants have been operating a business on it without paying rent. They've made false statements about me, potential future buyers. They've contacted my land contract seller to try and usurp me and purchase my debt. The land contract seller contacted me to alert me immediately and denied them. They filed a PPO against me. And I haven't even been to my property for close to a year because of how hyper hostile the experiences have been. I won't even take my family there. The PPO was denied immediately. They then sued me in circuit court before my attorney could file for this eviction. This is the fourth hearing over what began as a simple non-payment eviction. They refused to negotiate. Their actions appear intended to harm my family financially. I'm simply trying to protect my property and resolve this properly. Thank you.
Thank you. And to the parties, as soon as the paperwork and the attorneys and the parties are in order, I will expeditiously get this matter to trial, if that's where we have to head. I don't have a problem doing that, but I can't set things when things are in such disarray, quite frankly. The 19th, 2025, 1 p.m. Your attorney, once you hire them, will know.
Cases like this demonstrate how legal disputes often become more complicated because of procedural and ethical questions, not just the underlying facts of the dispute itself. Every decision made outside the courtroom can eventually become just as important as the arguments made inside it. If you found this case as fascinating as we did, be sure to hit that like button, share your opinion in the comments below, and don't forget to subscribe for more in-depth courtroom breakdowns, real legal analysis, and the most compelling courtroom moments from across the country. We'll see you in the next case.